Hi, this is Richard Chamberlain. I'm one of the attorneys at the Legacy Law Group in Perrysburg, Ohio. Welcome back to the Protecting Your Family's Future podcast. This is episode number 59 of our podcast. And today we're going to be talking about guardianships and how to establish them. For the last couple of weeks, we've started looking at guardianships and the different types of guardianships, whether it's a guardian of the person or guardian of the estate, whether the ward is a minor or an incompetent adult. Today, we're going to look at how do we actually start a guardianship? How does one get established? Now, again, this is going to partly depend on whether the ward or the proposed ward is a minor or an adult. But generally speaking, the person who would like to be appointed the guardian will file an application with the probate court asking to be appointed their guardian. If it's a minor, then they need to state why a guardian is needed. The Ohio law on the subject says that a guardian of a minor child needs to be appointed if the minor child does not have a father or a mother, or if the parents are not capable of adequately providing for the child, or if the court otherwise feels it would be in the minor's best interest to have a guardian established. So in that application to be appointed guardian for the minor, the applicant must make that statement. Why is it necessary that a guardian be appointed for this proposed ward? Now, on a guardianship application for an incompetent adult, a document called a statement of expert evaluation needs to be provided with the application. That would be a statement that is completed by a doctor who has examined the proposed ward. The statement states essentially that a guardianship is needed because, and the doctor goes into some details on their findings. There's an actual statement that either the proposed ward is not capable of managing their own property and financial affairs, or they're not capable of looking after themselves, and therefore a guardianship is recommended by the expert in that form. And of course, that is attached to the application for appointment of guardian. Now, once the application has been completed, there are a host of other documents that need to be filed with that application, regardless of whether it is a minor proposed ward or an incompetent adult ward. Generally speaking, the court needs to know that the interested parties are being informed that this application has been filed, because the court will hold a hearing on the application where the applicant will go to court, and the proposed ward has an opportunity to go to court. Other people who are interested can also go to court. That would be other family members of the proposed ward, whether it's parents or siblings, other close family members. And they have an opportunity to hear the allegations that are being made about whether the guardian should be appointed. They can actually file competing applications to be appointed guardian. So sometimes if you have someone who is needing a guardian, you'll have more than one person file an application with the court to be appointed guardian. The court will hear all of those at the same time, and they will choose the most appropriate person if a guardian is actually needed. So it's important that all the people who are interested or potentially interested in the guardianship estate be notified of the hearing. So the court needs to know who all of those people are. They need to be told about all of the details supporting the need for that guardianship. The proposed guardian or the applicant also needs to get a background check completed so that the court knows that this person is a suitable person. They're trustworthy. They don't have a criminal record. They will do a good job in looking after the best interests of the ward. So once all of those papers are filed, the court will schedule a hearing, and that's generally about 30 days after the application has been filed. That gives the court time to get notice to all of the interested parties, for an investigator to do their own investigation in whether or not a guardian is needed and whether the applicant is an appropriate person. The hearing is then held. All of the interested parties, everyone who has received notice, can come. Of course, the applicant needs to come, but anyone else is able to come and be heard on the matter if they have an opinion one way or the other about whether the guardianship should be established and whether this applicant should be the person appointed to be the guardian. So that's generally the process. It's making the court aware that a guardian is needed and why, and then letting the court know who else might be interested in the best interests of this ward, having a hearing on the matter to determine what's going to be in the best interest of the ward, and then having the court make the decision on the application. So I hope that's helpful for you today in understanding that process. As we continue our discussion, we'll be looking at what the actual duties of the guardian are. So over the next couple of weeks, we'll look at those questions to help kind of fill out those details on what guardians actually do. If you have questions about guardianships in Ohio and how they work, and if you need help with a guardianship that you are involved in or you need one to be established, you can reach out to us. The contact information for us is in the show notes. And thanks for joining us today, and we'll see you next week.